Welcome to the deep dive. Few topics in the United States stir up quite as much passionate debate and really personal stories as immigration.
That's definitely true.
It's an issue that touches on everything, doesn't it? National security, economic growth, and maybe most profoundly, individual lives, the fabric of our communities.
Absolutely. It's woven into so many aspects of American life.
So today we're taking a deep dive into two distinct, yet I think profoundly interconnected threads of this really complex tapestry.
Okay.
We've got a significant new legislative push aiming for comprehensive reform, and then also a critical legal battle that's unfolding right now over an existing humanitarian protection.
And it's incredibly illuminating, actually, to see how these two narratives, while, seemingly separate in their immediate focus, they truly highlight the multifaceted challenges and the diverse, sometimes really conflicting approaches to immigration in America right now.
So we're going to explore not just the what of these developments.
Yeah, we need to get beyond just the headlines.
It's exactly. We want to get into the why behind the policy decisions and critically the potential. So what does this actually mean for millions of people and for the nation as a whole?
That's the goal,
Right.
understanding the real-world implications.
So our mission for you today is basically to give you a shortcut, a way to get truly well-informed on these critical developments. First, we'll unpack the ambitious Dignity Act of 2025. It's a bipartisan effort aiming to fundamentally reshape U.S. immigration policy.
A big undertaking.
Huge. Then we'll pivot to a more immediate and, frankly, pretty urgent situation. The recent legal development surrounding temporary protected status, or TPS, for Nepal.
Right, that one's moving fast.
It is. And what this means right now for thousands of individuals. So let's get started. Okay, let's begin with the Dignity Act. Now, this isn't just another proposal sort of floating around Washington. It's H.R. 4393.
Right, it's a specific bill.
Introduced very recently, actually July 15, 2025. And the sponsors are key here. Representatives Maria Elvira Salazar, who is a Republican from Florida, and Veronica Escobar, a Democrat from Texas.
Okay, that's interesting right off the bat. Florida and Texas, Republican and Democrat.
Exactly. The fact that this bill has such prominent bipartisan sponsorship, a Republican and a Democrat leading the charge, that immediately sends a powerful signal, I think.
Oh, absolutely. In a political landscape often defined by, really deep partisan rifts, especially on immigration,
Especially immigration.
this kind of cross-party collaboration is, well, it's frankly almost unprecedented in recent years. It signals a serious intent, at least on their part, to find some common ground.
On an issue that has just frustrated lawmakers for decades.
Decades, yeah. That bipartisan backing is genuinely noteworthy. And if we look at the bigger picture, this bill truly represents one of the most comprehensive bipartisan efforts in recent memory to overhaul U.S. immigration policy.
Comprehensive is the word.
It is. Its stated aim is ambitious, right?
Yeah.
To balance robust border security measures with pathways for legal status for undocumented immigrants, alongside a broad modernization of existing immigration pathways.
It's trying to do it all, basically.
In essence, yeah. It's an attempt to bridge those deep partisan divides that have left this issue unresolved for so long, moving beyond the kind of traditional stalemates we've seen.
You think about past attempts.
Exactly. Think about past attempts at comprehensive immigration reform, like the 2007 Bush-Kennedy bill or the 2013 Gang of Eight bill. So many of them faltered precisely because they couldn't sustain that bipartisan consensus.
They just fell apart.
They did. This bill seems to be trying to learn from those failures by tackling the issue from multiple angles simultaneously, rather than, a piecemeal approach, aiming for a kind of grand bargain.
Okay, now what's crucial to understand here, and this is really interesting, is that this isn't entirely new.
Right, there's history here.
There is. It's actually a refined successor to the Dignity Act of 2023, which was H.R. 3599. That earlier version, like so many other comprehensive immigration bills, ultimately just stalled in committee. It expired at the close of the 118th Congress.
Yeah, the legislative graveyard is full of those.
It really is.
Yeah.
The landscape in Washington is littered with good faith efforts that just couldn't make it across the finish line. Now, the biggest change this time around, and it feels deeply strategic,
Okay.
is the removal of the previously controversial redemption program.
Ah, yes, that was a key point of contention.
It was. That 2023 program offered a specific, albeit conditional, pathway to citizenship.
Right. And that word, citizenship, often draws immediate and intense fire.
especially from the more conservative wing of the Republican Party, who often view anything like that as a form of amnesty.
Yeah, that's the trigger word.
So instead, the 2025 version focuses on something called dignity status.
Okay, dignity status, what does that mean practically?
It means a renewable legal status, crucially, not a direct path to citizenship.
Okay, so decoupling legal status from citizenship, at least initially.
Exactly. This removal of the direct citizenship path seems like a deliberate, very calculated move. It seems designed to garner broader support, particularly among Republicans who have traditionally resisted any legislation perceived as granting amnesty.
It prioritizes maybe integrating individuals into the workforce, ensuring they're tax-paying members of society.
Right, paying into the system.
Over immediate, full civic integration, like voting.
It's a significant concession, you have to say, and maybe a pragmatic attempt to increase the bill's viability in what is still a very, very challenging political environment for immigration reform.
No doubt about that. It's trying to thread a very difficult needle.
Okay, let's dive into the core components of this bill, because like you said, there are a lot of moving parts. Each one addresses a different facet of the immigration system.
Right, it's multi-pronged.
So, on border security, the bill proposes some truly significant enhancements, things aimed at making our borders, both more secure and maybe more efficient.
Okay, what kind of things?
For instance, it mandates nationwide implementation of E-Verify.
E-Verify. That's been discussed for years.
For years. And for those maybe unfamiliar, E-Verify is that internet-based system that allows businesses to electronically confirm if their employees are eligible to work in the United States.
By checking I-9 info against government databases?
Exactly. Comparing information from an employee's I-9 form against data from DHS and the Social Security Administration, this would be a big step towards ensuring a legal workforce, cracking down on undocumented employment.
Huge implications for employers, obviously.
Massive. Beyond E-Verify, the bill calls for substantial construction and modernization of border infrastructure and ports of entry.
So not just the wall.
Right, it's broader than that. It seems to be about investing in advanced surveillance technology, improving processing facilities at legal crossings to handle increased traffic more efficiently, upgrading roads, maybe fencing in certain strategic areas.
Infrastructure investment.
Yeah, and it also proposes increased criminal penalties for illegal border crossings and for human smuggling operations.
Okay, so a definite emphasis on deterrence and enforcement there, too.
Seems like it. These measures collectively indicate that a primary priority for the bill's drafters is not just managing the flow of people, but also imposing stricter controls and consequences for those trying to enter outside legal channels.
Signaling that security is really a foundational element of this whole reform package. You need that to bring certain people along.
Absolutely. It feels like a prerequisite for the other parts.
Okay, so this leads us to really a central piece of the Dignity Act. The Dignity Program itself.
Right. What is that exactly?
Well, this program is designed to offer a 7-year renewable legal status to undocumented immigrants who meet some very specific and, frankly, quite stringent conditions.
Okay, like what?
First, eligibility. Individuals must have entered the U.S. before December 31st, 2020.
Cutoff date. That's crucial.
Very crucial. It means it doesn't apply to more recent arrivals. That's a point proponents often emphasize to counter those, open borders critiques.
Okay. What else?
Beyond that, individuals have to meet a pretty robust set of criteria. They need a clean criminal record, no serious felonies, no pattern of significant misdemeanors.
Standard requirement, usually.
Pretty standard, yeah. They must pass thorough background checks, including biometrics, national security screenings, and here's a big one. They must commit to paying a substantial $7,000 fine over 7 years.
Wow, $7,000.
Yeah, that translates to about $1,000 a year, which, even spread out, can be a significant financial burden for many families, especially those in lower-wage jobs.
Yeah, that could be a real barrier for some people.
It could certainly push them into debt or just make participating in the program financially prohibitive. It might undermine its reach, honestly.
What else is required for this dignity status?
They also need to provide consistent proof of employment, show they've been paying their taxes, demonstrating that contribution to the economy.
So working and paying taxes.
Right. And provide evidence that they are actively learning English or have already attained a certain level of English proficiency.
Okay. And critically, as you mentioned, while this program grants work authorization, travel authorization.
Which are huge practical benefits.
Absolutely. But it does not provide a direct path to citizenship.
Right. And the implications of renewable status versus a path to citizenship are, well, they're profound.
How so?
Renewable status offers a form of legal stability, sure. It allows people to live and work without that constant fear of deportation hanging over them.
Which is huge.
It is huge, but it doesn't offer the full integration and security that comes with citizenship. Things like voting rights, serving on juries, the ability to sponsor other family members more easily.
So they'd always be sort of contingent.
Effectively, yeah. It means beneficiaries would be in this continuous cycle of renewal, potentially leaving them in a somewhat perpetual state of legal limbo without the ultimate security of full citizenship. A different kind of uncertainty, perhaps.
Okay. Now, the Dignity Act also specifically addresses a population that, it has been living in immense uncertainty for years.
Yeah.
The Dreamers.
Right. Individuals brought here as children. Many DACA recipients.
Exactly. What does it do for them?
The bill establishes a clear and defined path to permanent legal residency for them. Green cards.
Okay, so not just temporary status, but permanent residency.
Right. Provided they meet specific criteria related to education, employment, or military service.
Like what kind of criteria?
For example, they might need to have graduated from a U.S. high school, pursued higher education, maintained continuous employment for a certain period, or served honorably in the U.S. military.
So demonstrating integration and contribution.
Exactly. This is a really big deal for a population that, has grown up in the U.S., contributed to our communities, often speaks only English, and yet constantly face the threat of deportation to countries they barely remember.
It offers a future.
It provides them with a clearer future, a sense of stability that they desperately need to fully integrate and, frankly, thrive.
That seems like a less controversial piece, maybe?
Generally, yes. There's broader bipartisan support for helping Dreamers, although the specifics can still be debated.
Okay. What else is in there?
Well, a particularly intriguing element within the Dignity Act is the inclusion of something called the American Worker Fund.
American Worker Fund. How does that work?
This fund, quite uniquely, would be financed through the very penalty fees collected from the Dignity program itself, that's $7,000 per person.
Ah, so the fines pay for this fund.
Exactly. Its stated purpose is to reskill and upskill American workers who might, foreseeably be displaced or affected by immigration patterns or even by the broader ongoing march of automation in the economy.
That's an interesting linkage.
It's an innovative attempt to address potential domestic impacts of immigration by directly funding workforce development and training programs.
Like job training.
Yeah, it could support things like vocational training for high-demand trades, coding boot camps, maybe educational grants for workers transitioning out of industries impacted by global economic shifts.
So it's trying to build buy-in from native-born workers.
That seems to be the idea. This mechanism is a novel approach to build broader political support for immigration reform by demonstrating a tangible benefit for existing American workers, aiming to mitigate any perceived negative effects on the domestic labor force and foster a sense of shared economic benefit.
Clever politics, maybe?
Potentially, yeah. A way to address the economic anxiety argument.
Okay. And finally, the bill aims to tackle one of the, most bottlenecked and emotionally charged areas of the system. Asylum and general immigration processing.
Oh, yeah, the backlogs are legendary.
Infamous. So what does it propose here?
It proposes creating 3 new humanitarian processing campuses along the U.S.-Mexico border.
Processing campuses, what are those?
The idea seems to be to streamline the initial stages of asylum claims, provide a more organized, maybe more humane environment for initial screenings and interviews, rather than relying solely on overwhelmed Border Patrol facilities.
So get people out of those holding cells faster.
Potentially. The bill also mandates, and this is ambitious, that asylum adjudications be completed within 60 days.
60 days? That seems incredibly fast.
It's a stark contrast to the years-long waits many asylum seekers currently face. Some individuals can wait 5 years, even more, just for their case to be heard.
So a huge potential change in efficiency.
Potentially, yes. Furthermore, it suggests modernizing the entire immigration court system with digital processing, aiming to significantly reduce those notoriously long visa backlogs that can keep families separated for decades.
Digitizing the courts.
Makes sense.
These reforms could drastically improve efficiency, speeding up processing times, reducing the immense caseloads that currently just bog down the system.
And from a humanitarian perspective.
Faster adjudications could prevent prolonged detention, reduce that agonizing uncertainty for asylum seekers, ensure their cases are heard more promptly.
But the challenge?
The challenge, of course, will be to ensure that speed doesn't compromise fairness or thoroughness in these critical, often life-altering decisions. You need due process.
Right. Efficiency versus fairness, a classic tension. Okay, so let's look at the bigger picture in Washington. As of, say, July 22, 2025, where does the Dignity Act actually stand?
Right, what's its status?
It's still in its early legislative phase. It's been formally introduced, referred to several key committees: Judiciary, Homeland Security, Ways and Means.
The big ones for immigration.
Exactly. These are the crucial committees that will determine if the bill even sees the light of day on the House floor. As of that date, no subcommittee hearings had been scheduled yet.
So, still a long road ahead.
A very long way to go before advancing. However, a significant indicator of its potential viability is the fact that it has those 20 bipartisan co-sponsors, evenly split, 10 Republicans, 10 Democrats.
That is unusual.
That kind of cross-party support is exceptionally rare on immigration legislation, which, as we know, often becomes a political football.
Right.
Moreover, it's earned a formal endorsement from the influential Problem Solvers caucus.
Ah, the problem solvers. They're important.
They are. They comprise over 60 centrist members of Congress from both parties. They play a pivotal role in identifying and advancing cross-party legislation.
So their endorsement carries weight.
It's a strong indicator of centrist momentum. It signifies that a significant block of moderate lawmakers from both sides see this bill as a viable, maybe necessary step towards addressing immigration challenges.
Suggests a potential pathway through the gridlock.
It suggests a potential pathway, yes. Their backing offers a critical mass for initial movement, at least.
But there's always a but, isn't there? It's certainly not all smooth sailing.
No, definitely not.
There are clear and, frankly, formidable barriers to passage that this bill will need to navigate.
Like what?
Well, the current polarized political climate means deep skepticism, especially from some conservatives who still perceive the Dignity program as a form of amnesty, even despite the explicit exclusion of a direct citizenship path.
The A word is hard to shake.
Very hard. And this debate is highly visible, very emotional. It plays out constantly on social media, platforms like X, where, the nuances of the bill just get lost in simplified, charged rhetoric.
Sound bites versus policy details.
Exactly. There's also significant inter-party resistance within the House GOP. Groups like the Freedom Caucus are already criticizing the proposal.
Arguing it doesn't go far enough on enforcement.
Right. They argue the bill doesn't go far enough on deterrence and border enforcement. They view the Dignity program as far too lenient, basically. They believe any reform must prioritize securing the border above all else, even if it means foregoing other components.
So pressure from the right flank.
Definitely. And of course, looming over everything are the 2026 midterm elections.
Election year politics.
Always. Lawmakers may be particularly reluctant to take bold stances on such a divisive issue, fearing political backlash during their campaigns. History shows immigration reform often gets sidelined, or worse, weaponized during election cycles.
Makes compromise incredibly difficult.
So, this bill faces headwinds not just from the opposing party, but from within its own ranks, creating a very, very narrow path to success.
Okay, so this leads us to a critical question then. What are the reasons for optimism amidst these very real hurdles? Is there any hope?
Well, maybe. As we discussed, that Problem Solvers Caucus endorsement is certainly a significant signal of centrist momentum. It brings considerable weight, a potential pathway for the bill to gain traction.
Okay, and the changes from 2023?
That strategic removal of the citizenship path in this 2025 version might indeed ease some conservative opposition by directly addressing their primary concern about amnesty.
Okay.
It could make it more palatable for those who oppose anything resembling, what they call a mass legalization without significant enforcement first.
So the compromise might actually work politically.
It might. And critically, there seems to be broad-based support from a diverse coalition outside Congress. Immigrant advocacy groups, while maybe seeing its limitations, largely view it as a meaningful step forward.
Okay.
Business leaders, who desperately need a stable and legal labor force, particularly in certain sectors, and moderate lawmakers from both sides of the aisle who are tired of the gridlock.
So a potential coalition for reform.
This diverse coalition could help build a stronger, more resilient push for the bill. But the big question remains,
Yeah.
do these compromises, particularly that shift from a direct citizenship path to renewable legal status, actually create enough political space for the bill to advance?
Or is immigration reform just too toxic, too complex, and deeply entrenched in this environment for any compromise, no matter how carefully crafted, to truly succeed.
It's a delicate balance. The path forward is far from guaranteed. The coming months are going to be incredibly telling.
We'll be watching closely.
So, what does this all mean for the Dignity Act of 2025? As of today, July 22, 2025, it remains in committee, poised at a critical juncture.
It's a serious effort.
It is a serious bipartisan effort, clearly designed with strategic compromises to appeal to a broader base. It indicates a genuine desire by its sponsors to move past the entrenched stalemate.
But its future.
Its future is far from certain. It's navigating the treacherous waters of congressional gridlock, intense political polarization, and those upcoming election year sensitivities.
Yeah.
The coming months will be crucial in determining if this ambitious piece of legislation advances or becomes another casualty of the long-standing, seemingly intractable debate over U.S. immigration policy.
Another one for the legislative graveyard, potentially.
We'll certainly be keeping a close eye on its progress or, frustrating lack thereof. Okay, now, let's shift gears. Let's turn to another critical facet of U.S. immigration, one with immediate, very personal stakes for thousands of individuals right now.
Right, this is happening as we speak, essentially.
It is. We're talking about temporary protected status, or TPS.
TPS.
This status, for listeners who might not know, is a humanitarian designation. It's granted by the Department of Homeland Security to nationals of specific countries affected by extraordinary events.
Like war or natural disasters.
Exactly. Ongoing armed conflict. Environmental disasters like earthquakes or hurricanes or other temporary severe conditions that make safe return impossible.
It allows people to stay and work legally for a time.
Right. It allows individuals from those designated countries to live and work legally in the U.S. And crucially, it protects them from deportation while the designation is active.
Okay. And this specific case involves Nepal.
Yes. For Nepal, this designation was first granted back in 2015.
Following the earthquake.
Following that catastrophic 7.8 magnitude earthquake that devastated the nation, caused widespread death, destruction, made safe return impossible for many of its citizens living abroad at the time.
A clear-cut case, it seemed, of urgent humanitarian need back then.
Absolutely.
So this brings us to the really pressing question. What is the immediate impact of the recent court decision we're discussing for these individuals, these Nepali TPS holders?
Yeah, what happened?
Well, as of August 20, 2025, the U.S. Court of Appeals for the Ninth Circuit made a unanimous decision, and it has profoundly impacted approximately 7,000 Nepali TPS holders.
Okay. What did the court decide?
A 3-judge panel on the court overturned a lower court's temporary stay.
The stay that was protecting them.
Exactly. It effectively clears the path for the Trump administration to terminate TPS for nationals of Nepal and also Honduras and Nicaragua, who were part of the same lawsuit.
Wow. So the termination can proceed.
Yes. And this means an immediate loss of legal status, loss of their work, permits those employment authorization documents, or EADs, and most importantly, loss of deportation protections for these individuals.
And it's urgent because...
It's particularly urgent because their TPS was already scheduled to expire on August 5, 2025. This ruling basically retroactively confirms that termination date.
So their status effectively ended weeks ago.
Legally, yes. And to fully grasp what losing legal status means for daily life, I mean, imagine waking up one morning and your entire foundation, maybe built over nearly a decade, it suddenly vanishes. Your job, the one you've held for years, is now immediately at risk because your work permit is no longer valid.
Can't legally work.
Right. You might face immediate eviction notices because landlords require proof of legal residency.
Think instability.
Huge housing instability. Think about children who have grown up here, speak English, attend American schools.
U.S. citizen children.
Often U.S. citizen children. They could be pulled out of classrooms, face the traumatic prospect of their parents being apprehended and deported.
Just devastating for families.
Absolutely. Simple acts like driving, having a driver's license, accessing health care, even just walking down the street become fraught with the fear of being picked up by ICE.
Constant fear.
It creates immense instability, pervasive fear, widespread uncertainty. It effectively unravels years of established lives, contributions within American communities, family stability. It's a truly terrifying scenario for thousands.
Okay, let's unpack the timeline of this because it seems like a rapidly evolving legal saga.
Yeah.
Where did it start?
Well, it begins back on June 5th and 6th of this year, 2025. That's when the Department of Homeland Security, under Secretary Kristi Noem, announced the initial termination of TPS for Nepal.
Okay, so DHS made the decision to end it back in June.
Right. Their stated rationale was that conditions in Nepal had improved sufficiently since the 2015 earthquake.
So the reason for the protection was gone, in their view.
In their view, yes. That the country no longer warranted the continued humanitarian protection that TPS provides. This was part of a broader push by the administration, frankly, to reassess and often terminate many existing TPS designations.
A shift towards a stricter interpretation.
Exactly. A shift towards a more restrictive interpretation of what temporary protection means.
Okay, so DHS announced termination. What happened next?
What's truly striking is what happened next, and the sheer force of the judicial response initially. On July 31st, 2025, a federal judge in the Northern District of California, Judge Trina Thompson, issued a temporary stay.
In the case National TPS Alliance v. Noam.
That's the one. This order was a lifeline. It blocked the termination until November 18th, 2025, and crucially, it also extended the employment authorization documents, the work permits, for affected individuals until that same date.
So a temporary reprieve.
A temporary reprieve. But Judge Thompson's ruling wasn't just a procedural delay. It was delivered with extraordinarily strong and pointed language.
Okay. Like what?
She stated unequivocally that the Trump administration's decisions to end these TPS programs were based on a preordained determination to end the TPS program rather than an objective review of the country conditions.
Wow. So accusing them of making the decision first, then finding the reason.
That's essentially what she's implying, suggesting a strong judicial skepticism about the administration's stated motives, implying the decision was driven by policy goals, not objective criteria based on country conditions.
Did she say anything else?
She went even further. She invoked powerful historical parallels, likening terminating TPS to the Atlantic slave trade, arguing that the United States has a long history of transporting individuals against their will to places unfamiliar with them.
That is incredibly strong language from a federal judge.
Incredibly strong. She also accused the administration of telling the approximately 60,000 people across these TPS designations to atone for their race, leave because of their names, and purify their blood.
Whoa. The rarity and significance of such historically charged, emotionally resonant language from a federal judge cannot be overstated.
Absolutely not. Judges typically use very measured, very legalistic terminology.
Yeah, not language like that.
For a federal judge to employ such comparisons, it signals an extraordinary level of concern, a deep belief that the administration's actions not only potentially violated legal procedure, but also carried profoundly troubling, potentially discriminatory implications.
Touching on fundamental rights and dignity.
Exactly. It indicated a court perceiving a profound injustice was potentially occurring.
Okay, so Judge Thompson issues this really strong stay. How did DHS respond? I imagine not quietly.
Not quietly at all. Here's where the narrative takes a really sharp turn, because DHS didn't mince words in their response to Judge Thompson's powerful and highly critical ruling.
What did they say?
Assistant Secretary Tricia McLaughlin issued a fiery statement, really not holding back her condemnation. She immediately countered the judge's assessment, calling the ruling itself a major victory against what she termed unvetted immigration.
Calling the judge's stay a victory against immigration. That's twisted logic.
It's certainly pointed rhetoric. She then directly attacked Judge Thompson's credibility, specifically referring to her as an activist judge.
The classic label.
The classic label. And saying her ruling sounded like a New York Times opinion piece, a clear attempt to undermine the judicial authority and impartiality of the decision.
Trying to politicize the judge.
Seems like it. McLaughlin argued that TPS has been abused as a de facto amnesty program for decades, fundamentally disagreeing with its application as a long-term humanitarian measure, framing it as executive overreach that needed correction.
So doubling down on their rationale for termination.
Doubling down and escalating the accusations. She alleged the judge was race-baiting to distract from the facts and president's constitutionally vested powers under Article 2.
Wow. Accusing the judge of race baiting.
Yes. DHS was very clear in their intention. We will appeal, and we expect a higher court to vindicate us.
Okay, so this direct and acrimonious conflict between the judiciary and the executive.
Characterized by such charged personal language from the executive branch.
It just underscores the immense politicization of immigration policy, doesn't it? Yeah. And the deep ideological chasm between different branches of government on this.
Absolutely. It highlights a system where fundamental disagreements can quickly escalate into very public, very bitter disputes.
So DHS said they would appeal, did they?
And indeed, they did appeal, acting with remarkable speed. On August 20th, 2025, just a few weeks after the stay,
Okay.
a three-judge panel of the Ninth Circuit Court of Appeals lifted the stay.
So the appeal was successful.
It was. Crucially, and quite notably, in legal circles, they did so without issuing a detailed opinion. They simply gave DHS the green light to enforce the termination.
No explanation. What does that signify?
Well, the absence of a detailed opinion can signify several things. It might mean the court chose not to elaborate on its legal reasoning, perhaps considering the arguments for overturning the stay straightforward enough not to require extensive justification.
Or maybe they wanted a swift resolution.
That's possible too, given the urgency. It also means less for legal analysts to dissect, potentially allowing the decision to stand without setting clear precedent on those specific, very strong points raised by Judge Thompson's initial ruling about motive and historical parallels.
So the controversial parts of her ruling weren't really addressed by the higher court.
Not in a written opinion, no. DHS immediately hailed this reversal as another major victory in their efforts to address what they continue to describe as unvetted immigration.
Right. And where does that leave things now?
As of today, August 21st, 2025, the official USCIS website, that's U.S. Citizenship and Immigration Services, still references the July 31st stay. It hasn't yet been updated.
There's a lag in official communication.
There seems to be. DHS is expected to prepare and release next steps and formal guidance on the immediate implementation of this termination very soon. But right now, there's uncertainty even about the immediate procedural steps. Hashtag tag 2.3, immediate and broader implications for Nepali TPS holders.
Okay, so let's get practical again. What does this all mean right now for the 7,000 Nepali TPS holders who've been living under this protection for years?
Yeah, the human impact.
With the stay lifted, TPS for Nepal is now officially terminated. And critically, it's terminated retroactively to August 5, 2025.
Backdated.
Yes, which means the beneficiaries are no longer authorized to work under their TPS-linked employment authorization documents, their EADs.
Their permission to work is gone.
Gone. Their legal status, which offered that fragile stability, has evaporated. And many may face immediate deportation unless they happen to have other forms of relief pending.
Like a separate asylum case or green card application through family.
Exactly. Things like a pending asylum application, or an application for adjustment of status through a family-based petition or maybe employment sponsorship. But if TPS was their only status,
they're now undocumented and potentially removable.
That seems to be the stark reality. For thousands of individuals, it's an abrupt, terrifying, and profoundly destabilizing shift, upending the lives they've meticulously built here over almost a decade.
Okay, so this leads us to that crucial question. What tangible options remain for these individuals now facing such immediate, profound uncertainty?
Are there any paths forward?
Immigration attorneys across the country are urgently advising TPS holders to seek immediate legal counsel, emphasizing the critical, time-sensitive nature of their situation. Don't wait. Possible pathways, though they're limited and often complex, include adjustment to permanent residency, getting a green card through family-based petitions, if they have eligible U.S. citizen or permanent resident relatives who can sponsor them.
Spouse, parent, adult child.
Right, those types of relationships. Another avenue is employment sponsorship, if an employer is willing and able to support them through a specific visa category, which can be difficult.
And expensive for the employer.
Often, yes. A third, often complex route is filing or perhaps refiling for asylum. There might be specific legal exceptions for missed filing deadlines because they held TPS status, but it's complicated.
So claiming fear of return now.
Potentially, if they have a valid claim. Some might also explore temporary protections like deferred action if it applies to their specific circumstances, but that's not a widespread or guaranteed option at all.
So not many easy answers.
Definitely not. And it's vital to understand that TPS itself does not provide a direct path to permanent residency. It was always meant to be temporary.
Even though it lasted years.
Exactly. Yet for many, it became a de facto long-term solution because conditions in their home countries, like Nepal after the earthquake, arguably didn't improve sufficiently for a safe return, or new problems arose.
And these people have built lives here.
Deeply. Many affected Nepalis have been in the U.S. for nearly a decade, building lives, contributing to local economies through their labor, paying taxes, and critically, raising U.S. citizen children.
The mixed status family issue.
Precisely. The termination of TPS risks significant family separation. There are an estimated 23,000 U.S. citizens living in mixed-status households with Nepali TPS holders.
23,000 U.S. kids whose parents could be deported.
That's the potential impact. U.S. citizen children who know no other home, speak English as their primary language, fully integrated into American schools and society, could face the trauma of their parents being deported.
Unimaginable.
And beyond individual families, this decision also risks the profound destabilization of established communities, particularly in places like Jackson Heights, Queens in New York.
A large Nepali community there.
A very vibrant community. Also Dallas, San Francisco, other areas where Nepali immigrants have built communities, established businesses, contributed significantly to the local social and economic fabric. The impact reverberates far beyond just the TPS holders themselves. #tag 2.4 reactions and next steps in the TPS battle.
As you can imagine, the reaction must be intense. Advocacy groups, community leaders.
Oh, absolutely. They're reacting strongly, describing it as a devastating blow. Organizations like the ACLU, the National TPS Alliance.
Plaintiffs in the case.
Right. They've unequivocally condemned the decision as a devastating setback for immigrant rights and humanitarian protection.
Are they giving up the legal fight?
No, they've pledged to continue the legal fight, exploring every available avenue. They're potentially seeking an en banc review by the full Ninth Circuit Court.
Okay, what's that?
That means a review by all the active judges of the court, not just the 3-judge panel. It's a rare but powerful mechanism to reconsider a panel decision, though it's usually a long shot.
Any other options?
They might even seek emergency relief from the Supreme Court, a last-ditch effort to temporarily halt the termination while legal challenges continue.
So the legal battle might not be completely over.
It might not be. And we've heard directly from affected individuals, too. Nepali TPS holder Sandhya Lama shared her despair, saying, "We built our lives here, our children go to school here, and now everything feels like it's collapsing."
Just heartbreaking. Her words really underscore the profound, immediate human impact of this complex legal ruling. Goes beyond legalities, touches fundamental human security.
Absolutely. And one fascinating aspect of this battle is the proactive role that local governments have played, even though immigration is largely a federal matter.
How so?
Cities with large Nepali populations, New York, Dallas, San Francisco, they've previously introduced various sanctuary measures, like restricting local law enforcement's cooperation with federal immigration agencies, aimed at protecting their immigrant communities.
Trying to create some local buffer.
Exactly. Now, they're expected to expand emergency support services in the wake of this decision, anticipating the immediate needs of their residents for things like legal aid, social services, food, and housing assistance.
Stepping in where the federal government is calling back.
In a way, yes. And more directly, remember that amicus brief? New York City, Los Angeles, and a coalition of 11 other local governments filed one in the National TPS Alliance v. Noam case.
A friend of the court brief.
Right. In that brief, they argued forcefully that ending TPS would cause widespread economic harm to their cities, disrupting labor markets, consumer spending. They argued it would create public health and safety risks by disrupting established social networks and access to care.
Making an economic and social argument.
Exactly. They highlighted the potential for significant family separations and community disruption, emphasizing the profound local impact of these federal decisions. And they lent significant credibility to the plaintiffs' arguments in court.
So why do local governments feel compelled to intervene like this in federal immigration matters?
Because they are the ones on the front lines dealing with the direct consequences, the community fallout. Whether it's economic disruption from lost workers or increased strain on social services or dealing with traumatized families, they often become de facto protectors of their residents, regardless of federal status, because the impact lands squarely in their cities and counties.
Makes sense. They see the reality on the ground. Now, this ruling, it doesn't exist in a vacuum, does it?
No, definitely not. Sadly, it echoes a broader trend we've seen. It aligns quite closely with the Supreme Court's May 2025 decision that also permitted the administration to end TPS for Venezuelans.
Right, another recent termination.
So it very clearly reflects what's been described widely as a Trump-era push to roll back humanitarian protections and enforce stricter, more restrictive immigration policies overall.
And the public debate reflects this division.
Oh, absolutely. Particularly on platforms like X, you see this ruling being viewed from starkly opposing viewpoints. For some, it's lauded as a legal turning point, a policy triumph for the administration. They see it as a necessary step towards regaining control of immigration, upholding the rule of law.
And the other side.
Simultaneously, it's being condemned as a major loss for immigrant rights, for humanitarian principles. Others see it as a cruel disregard for human lives and established communities. The polarization is intense.
So the situation remains incredibly fluid.
Extremely fluid. Emergency petitions from advocacy groups are certainly likely, as we discussed. We're still waiting for that immediate DHS or USCIS guidance on potential grace periods for work authorization or deportation relief.
Any chance of a temporary reprieve there?
It's possible they could grant a short wind-down period, but it's uncertain. Congressional Democrats might also try to revive legislative efforts for a permanent solution, maybe a pathway to residency specifically for long-term TPS holders.
Yeah.
But a deeply divided Congress makes that a very challenging path, as we saw when discussing the Dignity Act. Any legislative fix faces huge hurdles.
So for now, what's the bottom line for Nepali TPS holders?
For now, the most crucial advice is check uscis.gov regularly for official updates. Stay informed through trusted advocacy organizations, not just rumors. And critically, consult qualified immigration attorneys immediately to understand their individual options and legal remedies. Time is of the essence.
And for those in New York City?
For those in New York City, the Immigrant Affairs Hotline at 212-788-7654 is also available as a resource for assistance and information.
Okay, so stepping back now, trying to connect these two deep dives to the bigger picture, it becomes really clear that these two situations highlight distinct, almost contrasting ways that immigration policy gets shaped and challenged in the U.S.
How so? Contrast them for us.
Well, on one hand, you have the Dignity Act. That's a proactive, comprehensive legislative reform. This bill is attempting to construct entirely new pathways, modernize existing systems through painstaking bipartisan negotiation, building something new.
Building new policy from the ground up, designed hopefully as a grand bargain that addresses multiple issues simultaneously. It represents an optimistic, forward-looking legislative approach.
Okay. And the TPS situation.
On the other hand, you have the TPS situation. That's a reactive battle over the termination of an existing humanitarian status. It's primarily fought through the courts and administrative decisions by the executive branch.
Dismantling something that existed.
Exactly. Here, the focus is on dismantling existing protections. One aims to build new policy, to chart a forward course. The other is focused on undoing existing protections, pulling back from previous humanitarian commitments.
So different approaches reflecting different philosophies.
I think they really do reflect fundamentally differing political philosophies about immigration. One emphasizes finding a grand legislative solution that balances various interests through compromise. The other prioritizes executive discretion and enforcement power to roll back what it perceives as overly broad or perhaps misused humanitarian protections.
Right. And this is where it gets really complex, isn't it? Because in both of these scenarios, we see these inherent tensions, these often unspoken compromises that reveal the deep ideological rifts.
The fault lines.
The Dignity Act, for instance, explicitly excluded that direct citizenship path. We talked about that. It was a clear, deliberate compromise designed to attract Republican support, to make the bill more palatable by sidestepping the amnesty accusation.
Right. A political calculation.
But for many advocates, and certainly for the immigrants themselves, that's exactly where it falls short. They see it as potentially creating a permanent second-class status, where individuals can contribute economically but never fully participate as citizens.
A major point of contention even among supporters.
Absolutely. Then, in the TPS case, you have DHS arguing that it's been abused as a de facto amnesty program, implying it deviated from its original temporary purpose and became a backdoor to permanent residency.
While advocates
vehemently emphasize the vital humanitarian protection it offers. They stress the unstable conditions back home, the deep community ties these individuals have fostered over years, decades even, within the U.S.
It's just a constant fundamental tension, isn't it, in U.S. immigration policy, where that desire for robust border security and enforcement clashes directly with the humanitarian imperative and just the realities of human lives built within communities.
Two sides talking past each other, often.
And this brings us to a crucial, maybe overarching question. These are rarely clean-cut issues with easy answers, right?
Definitely not.
The language used by all sides, you hear amnesty, open borders on one side, you hear racial animus, humanitarian crisis on the other. It just underscores the profound ideological and emotional divides that animate this whole debate.
It's not just policy points.
No, it's about deeply held beliefs and values, concerns about national sovereignty, human rights, economic impact, cultural identity. The core challenge lies in finding genuine common ground when the fundamental definitions of what constitutes fair and effective immigration policy are so vastly different.
What one side sees as compassionate.
What one side sees as a compassionate humanitarian gesture, another views as an uncontrolled border threatening national security, and vice versa. It truly makes you wonder, what are the realistic chances of either side fully winning? Or finding a truly lasting solution given these deep-seated conflicts that often feel irreconcilable?
Seems unlikely.
It seems more likely, maybe, that these issues will continue to be litigated, debated, shifting back and forth depending on political ties, which party controls which branch of government.
Rather than reaching some stable, bipartisan consensus that satisfies everyone.
Which seems almost impossible in the current climate.
So what does this all mean then for who actually influences and makes these decisions? And how they do it? We've seen just a wide array of stakeholders involved in shaping U.S. immigration policy, each with their own interests, their own levers of power.
Yeah, it's a crowded field.
To the members of Congress, right? From the Problem Solvers Caucus, trying to find that middle ground, craft bipartisan solutions.
To the Freedom Caucus.
To the more conservative Freedom Caucus, pushing for stricter enforcement, less expansive pathways, often willing to block legislation that doesn't meet their very specific demands.
Then the executive branch.
Then there's the executive branch, represented by DHS, implementing, enforcing these policies, often through administrative rules, directives that can have immediate, far-reaching effects without Congress even acting.
And the courts.
And the courts. The federal judiciary, federal judges like Judge Thompson, the potential for the Supreme Court to weigh in, interpreting existing laws, challenging executive actions, sometimes with very strong language, as we saw.
A crucial check, sometimes.
A crucial check. Beyond just the federal actors, you have powerful immigrant advocacy groups. The ACLU, National TPS Alliance, tirelessly campaigning, often initiating legal challenges, lobbying for legislative change.
Business leaders, too.
Business leaders, industry associations, huge economic stakes in immigration policy, relying on immigrant labor for various sectors.
And local governments.
And crucially, as you highlighted, local governments like New York and Los Angeles stepping up. Even without direct legislative power over federal immigration, they try to influence policy through things like amicus briefs and protect their communities through direct support services, sanctuary policies.
It's truly a complex, multi-layered web of interconnected players, each with their own agenda, their own leverage points, their own impact on a system that affects millions.
A messy democracy in action, maybe.
You could say that. And what's truly fascinating here is precisely how all these different actors, from the federal level right down to the local level, try to shape immigration policy and its enforcement.
Using different tools.
Exactly. They each operate with different levers of power. Legislative proposals coming from Congress, judicial appeals, challenging decisions in the courts, administrative actions taken by federal agencies that directly impact lives overnight, and grassroots advocacy pushing for change from the ground up through public pressure, community organizing.
All aimed at influencing the system.
All aimed at influencing a system that profoundly affects millions of lives and, indeed, the very fabric of American society. The interplay between these diverse stakeholders creates a dynamic, often very contentious landscape where policy is rarely static. It's constantly subject to challenge, reinterpretation.
It underscores the enduring complexity, doesn't it, of immigration in the U.S. It's a battle fought on multiple fronts, with every decision reverberating across communities and families.
Couldn't have said it better myself. Hashtag tag outro.
Well, we've taken a deep dive today into two really critical ongoing narratives in U.S. immigration. First, the legislative ambition behind the Dignity Act, that comprehensive attempt at reform through bipartisan compromise.
A huge
And second, the immediate, very personal impact of the recent legal decisions regarding TPS from Nepal. A battle over existing humanitarian protections playing out in the courts and in communities right now.
Two very different sides of the same coin, in a way.
Exactly. It's abundantly clear that immigration remains one of the most complex, politically charged, and frankly, emotionally resonant issues facing the U.S. today. You have these ongoing efforts for comprehensive reform, often colliding with urgent legal battles over existing protections.
A push and pull.
A constant push and pull. It's a landscape constantly shaped by legislative attempts, judicial rulings, administrative actions, and really at its heart, the very human stories of individuals and families seeking safety, stability, and opportunity within our borders.
And as we connect this to the broader societal implications, thinking about everything we've discussed, Given the deep partisan divides, the constantly shifting legal landscape we've explored today,
Yeah.
it really prompts a fundamental question, I think. What do you, listening to this, think is the most effective and sustainable way for the U.S. to achieve a long-term, stable immigration policy? One that successfully addresses both its economic needs and its humanitarian concerns, really recognizing the human element at its core.
That's the billion-dollar question.
It is. And maybe even more broadly, how do we truly balance that desire for national sovereignty, for control over borders, with the undeniable realities of a globalized, interconnected world where human movement, human needs are constant and profound?
Finding that balance.
Finding that balance, something to truly mull over as these stories, both the Dignity Act and the TPS battle, continue to unfold.